Is this microphone on? Good. Well, if you could all take your places then, it's 8:30 starting time. When I was a judge, I found that some lawyers would come in late, and they would expect me to wait for them, but I would get on the bench and start the trial. And the jury then would have to watch them walk in late. And they only would do it once, and they knew that the trial would start on time. So I'm an on-time person. We welcome you out to this session. I want to make a correction in the program before you. It indicates that that this is a 2-hour session. At the beginning, it says 8:30 to 10:30, but you'll see there later there's a break at 9:45, and then we go into the first breakout session. So this is not for 2 hours, it's until 9:45, and we will stop promptly at 9:45. We've enjoyed having people come and discuss for the first part of the conference various theories about religious freedom, and it was good to hear these variety of think pieces to try and give us some structure as to where we're going or try to go. But we're going to do something a little more on the hands-on part of the program today. The difficulty is that as much as we're passionate about freedom of religion and choice, you don't have anything to protect you until you have a judgment from the court. And we can discuss the other issues, but when it comes to the practical enforcement, we need to have a court which can accept our arguments and enter orders and judgments which actually protect the rule of law and choice. And so freedom of religion is only a theory until it's put into practice. And I think we have to remember that part of it, that the courts play an indispensable end game of all that we're trying to do to enforce that part. And that's what our program is about today, is how do we get that last part done? We, as judges, of course, are governed by law. And so a good part of this is dependent upon the law of your particular country. But this is where the rubber meets the road, as they say. This is the end result of all you're trying to do. And so we're talking today about the rule of law in a changing world and what it deals with in religion. Just as an introduction to the rule of law, this actually is not a long time history. Prior to the French Revolution, there was no rule of law as such, because the executive, the legislature, and the judiciary was all in one person, the king. What the French Revolution did was it took the legislative part away from the king. And so there was the first division among the executive branches of government, so that the legislature was apart from the king, the executive. But under the French system, the judiciary remained under the king. The first effort to divide into 3 branches, separate branches between the executive, the legislative, and the judiciary, was the United States Constitution. And it was heavily debated. It was an issue of great importance because it was the first time they would ever have a judiciary that would be out on its own. In our debates that we had about the Constitution and its adoption, they occurred not by sound bites and by television. They occurred by people on both sides going out and writing essays, which were then published in newspapers. And so we have in the United States a collection of those who were in favor of this new 3-branch approach. And they were called the Federalists. And the 3 of them wrote under the pseudonym of Publius. And we study those in school and have studied them in school for some time. Fortunately, some years ago, a professor at the University of Chicago developed all of the Anti-Federalist papers. And because of that, we are now much more advised of what was actually going on and what was debating. And that's just an introduction to Federalist Papers 78, which was by Hamilton, which is very interesting, in which Hamilton says in this division that they're talking about, that the executive has the sword, the Army and Navy, the legislature has the purse, that is the power to tax and spend. The judiciary has neither, therefore it is its weakest branch. And this is the first discussion about whether they should be co-equal or not. And you might think that his idea was they would not be co-equal, and everybody, professors and lawyers and judges, all agreed with that until we got the Anti-Federalist Papers. 3 weeks before Federalist 78 was Brutus, the Anti-Federalist, number 9 and number 10, in which he indicated that the judiciary would be a threat. It would be given so much power that it would overturn the liberties. And he said that it would be felt at the hearth of every home. But that was the main point of debate that was going on in New York, which was a key state, and Hamilton on one side and with Brutus on the other. That has been a continuous issue in the United States since, and should be, because it is not a static thing of this balance. Sometimes one gets a little higher and then it goes down lower. And through our history, we've had this interaction. And in most countries now, we have a division where the judiciary is separate. But we always have to recognize that the power that is recognized is in the executive and the legislative. And to keep the judiciary in balance is the vital part so that we can have a rule of law. So the executive and the legislature can't trample over your constitutional rights. You must have a free and independent judiciary. And we struggle with that, as all do. So today what we're going to talk about is how the judiciary has become involved in this particular process. And we have brought in some experts, they're judges, to talk to us today. And we're going to do something just a little different. We're going to have questions that I'm going to ask them. Now, in our other programs, I know those speakers have done a tremendous job in preparing. My colleagues do not know what question I'm going to ask. We've done this before, and it's worked out amazingly well, because we get a fresh approach. And they're going to answer my questions, which will not be easy questions. And there's no real answer that is right or wrong. And we're going to go into this discussion. And I can tell you, promise, they do not know what questions I'm going to ask. And then after we finish, we're going to let you ask them questions too, with the time that we have remaining. Now, this is an undaunting task, and we just hope it'll work out, right? Let me introduce them to you. Justice Peter Toliken is a justice of the Supreme and National Court of Papua New Guinea. He was formerly Chief Magistrate Judge of Bougainville. He has come all the way from Papua New Guinea. I know him, he's a friend, and they do a tremendous job over there with their judiciary. The second person I'm introducing is the Honorable Chancellor Singh, who's just retired Chancellor of the Judiciary in Guyana. He's been Chancellor since 2005 and is the father of 2 children, which is his credential. He was a school teacher before he went into law and has been there for some time. They did not allow him in Guyana to rest in retirement. They've co-opted him, and he is now the new Dean of the Law School of the University of Guyana. And so he'll be leaving his judicial position and becoming an academic. The final person is Judge David Campbell. One of the justices of the Court of Malaysia was to be the final judge, but he couldn't get a visa for some reason. And at the very end, I asked Judge David Campbell to come over and be the third. He graduated at the top of his class at the University of Utah in law school, and then became my law clerk for 1 year. I've told him he's the best law clerk I ever had. He wonders if I tell all my law clerks they're the best law clerk I ever had. But truly, he was has a remarkable mind, enough so that his next year, following a clerkship with me, he clerked for the Chief Justice of the United States, Chief Justice Rehnquist, and he is very picky about the law clerks he did. He's passed away now. What we're going to do is to begin this discussion of the rule of law in the context of what it can do and has to do in protecting the rule of the religious rights of people. Now, for the first time, you're going to find out what the questions are, and I'm going to let them know what the first questions are. And I'm going to ask Chancellor Singh to be the first responder, and then we'll have Justice Toliken, and then finally Judge Campbell. Sometimes we have the problem in our individual judiciaries of a dominant church in the country. And sometimes there'll be pressure on government to adopt restrictive measures. Under the rule of law and our attempt to enforce it, should courts respond to level the playing field? That is it our responsibility to level the playing field as a judiciary? And if so, how do we go about it? Chancellor Singh?
Thank you, Judge. Good morning, everyone. Before I attempt an answer, I just feel very honored that Judge Wallace has described me as an expert, but I am recognizing my own limitations and inadequacies, so I thank him for conferring that title on me. The question is, when there is a dominant church, should the courts respond in a way to level the playing field? I would prefer to answer that question in the constitutional context of my country. And our Constitution provides that Guyana is an indivisible secular state. And as a secular state, there is no promotion or facilitation of any religious group or denomination aspiring to or being facilitated into a position of dominance in the society. And so the truth is that if a particular group were to complain that state action was resulting in the promotion of a position of dominance in the societal framework, then in the context of the Constitution, which provides for a secular state, I believe that the intervention of the court would be just in the circumstances.
Thank you, Judge. I also would like to start by thanking the organizers of this conference to invite me. The original invitation was to my Chief Justice, who couldn't make it. But I'm glad I'm here. And again, I take the same approach which Chancellor Singh took. And firstly, I do not consider myself as an expert in anything. Yes, I've sat on the bench for some 29 years, 5 of which is in the High Court. We also have a constitutional democracy, and styled under the US Constitution. And one of the things that our Constitution is strong about is the separation of powers of the 3 arms of government. As to the question, I perhaps can start with a statement on the preamble of our Constitution. You see, Papua New Guinea is a country of ethnic diversity. We've got 852 languages in a country of 8 million people, more than 1,000 tribes. And as you can imagine, with more than 1,000 tribes, you have more than 1,000 religious belief systems. So in that context, and in the context of our Constitution, the preamble to our Constitution pays homage to what the Constitution describes as noble customs and traditions passed down from our ancestors. But then it goes on to say that we also pay homage to our Christian heritage, which we inherited from our colonial administrators. But the Constitution, the country is not a Christian country as such. It is a secular country, and that is confirmed by the right to freedom of religion, conscience, and thought, which is entrenched into our Constitution as a qualified right, but it is one that is doubly entrenched. So it is not easy for the state to amend or alter those provisions. And we do not have a dominant Christian denomination. The Catholics make up about 26% of our population, followed by the Evangelical Lutheran Church, and others follow suit. But I think, for us as a constitutional democracy, it is important that us as the judiciary ought to maintain a very neutral role. Religious freedom also includes impartiality on the part of us who sit in judgment over our fellow men and apply the law impartially as we can.
First, let me say what a privilege it is to be in this group of people. I have a tremendous regard for those who run the center and the good work that they do, and an equally high regard for all of you who have come from around the world to take your time and effort to address these very important issues. And it's just a privilege for my wife Stacy and I to have this opportunity to be with you and rub shoulders with you for a few days. Like the other judges, I am no expert on international law and religion. I am a United States District Court judge, so I'm a federal judge in the United States. And that's the perspective from which I speak, which is a limited perspective, and I recognize that. So I'm happy to give my thoughts from that limited perspective, but obviously many of you have a broader perspective within which to place those thoughts. I think theoretically the answer to the question you asked, Judge, is in most countries, judges are not lawmakers. Our job is to apply and interpret the law, not to originate the law. And in that respect, it does not fall to us to try to level the playing field by creating new laws that might result in the leveling of the playing field. But as we all know, judges do have a powerful opportunity in many instances to give life to legal protections that are reflected in founding documents or in legislation or other laws that may have the effect of leveling the playing field. A good example is what Judge Wallace started with, and that is that a law on paper means nothing to the citizens until it is enforced in a court. And we all know that there have been countries that have wonderful protections written into their laws, but those protections have no real meaning in the lives of their citizens because the governments don't enforce them and apply them. And so judges do have an opportunity to level the playing field by bringing to life written protections that come to them from the hands of others in constitutions or legislation and that can protect minority rights. Another respect, I think, in which judges can do that is that most well, I shouldn't generalize because I'm no expert, but I think many constitutional protections are written in very general language. They are descriptions of principles rather than practical applications. The religious protections in our Constitution are 15 words long, and they include the phrases establishment of religion and free exercise, and it falls to the judges to give meaning to those words and how they apply in the everyday lives of citizens. And in interpreting and applying those laws, judges can, at times, level the playing fields. Another respect in which judges can do that is that when the rights of one group comes into conflict with the rights of another group, both claiming rights under the law, it often falls to judges to decide who prevails. And in that respect, sometimes it is a majority against a minority, and judges can level the playing field if it's consistent with the law that they are to apply. And there's lots of examples of that, including one that will be coming up in our Supreme Court in the next couple of months, where one group's rights versus another are coming into conflict on religious issues. And it will be up to the Supreme Court to say which interest prevails. Two other thoughts on that subject. I do believe that where the law protects minorities, judges have a responsibility to implement that law and protect minorities and level the playing field. And Judge Wallace did mention to me that we may be discussing the decision from a couple of years ago by Chief Justice Jilani of the Pakistan Supreme Court, where the Supreme Court of Pakistan took laws that were in the founding documents of the country and said these apply to minorities to curtail some of the actions of religious majorities, and very much acted to level the playing field. The last thought I would have is we talk about the rule of law as it applies in courts, but I think we all recognize that the rule of law has its most powerful effect not in a specific case where an individual's rights are vindicated, but when the citizens of a country voluntarily adhere to that law and accept that law and apply it in their everyday lives. That's, in my view, where the rule of law is truly powerful. And on that sphere, courts play a very important role in educating the public. The actions of the court does much to either educate the public concerning the reality of rights or educate them concerning the fact that rights aren't real, even if they're written into the Constitution. And courts can perform a very valuable educational role by the decisions they make in modeling to the country how minorities are to be treated under the laws of that country.
Chancellor Singh, you had one more comment you wanted to make?
My observation now is really in addition to the comments made by my colleague from Papua New Guinea. In some countries, one would find that a particular denomination or religion has greater appeal than some others. That is really the consequence of the exercise of the constitutional entitlement to freedom of religion and freedom of worship. So if religious dominance is examined in that context, there really could be no complaint, because for those who subscribe to that religious persuasion, they are really exercising a constitutional entitlement which is given to them, which results in this apparent position of religious dominance. And that, I believe, cannot be challenged. I think where contention arises is where, by state action, a particular denomination is promoted over minority groups. I just wanted to make that observation.
Just one comment in regard to whether, the judiciary can propagate a level playing field. For us in Papua New Guinea, I think the Constitution has done that for us. It provides as a fundamental right equality before the law. So I guess for us, you can't go any higher than that.
Thank you very much. I'm sure you can see perspectives are different. Chancellor Singh comes from a small country. Justice Toliken comes from a medium-sized country, and Judge Campbell comes from a very large country. Their perspectives are also interesting in their balance of where they come from, in that if you go to Papua New Guinea, there's a very fine metropolitan area, but there's still areas of Papua New Guinea where they've never grown out of the tribal areas. They still fight with spears, and it's a remarkable country because it's so diverse. And then Judge Campbell comes from a country that has had the benefit of a long history of working with the Constitution. So perspectives will change depending upon experience they've had, but overall you can see that the consistency they have about the rule of law. So let me turn to number 2, the second question, dealing with proselyting. This has become an important role of people who have desires to share what they have found. They believe that they can be of assistance to helping people change their lives, come closer to a supreme being, and become better citizens. And so that occurs, not infrequently. But on the other hand, it's usually members of other faiths that are talked to. And so there's some tension that builds up by the church that is losing the converts. And very often that's a very dominant church that's been the dominant church for the country for many, many centuries, or at least decades. And so the dominant church then has more contacts with the executive and the legislative branches, and then will implement very often restrictive laws that keep proselyters from invading their clan as they see it. And thus we have a situation where both see themselves as right, as the bringers of truth. And yet there is a problem with trying to solve that through the rule of law and making it effective. So each country will have their approach to it. Some will use government officers and some will use the courts. But let's see what the experience has been of the various countries. Chancellor Singh, would you mind starting off again first?
Well, I have to admit that this is not an experience. Sorry, thank you. I have to admit it's not an experience that is known in my country. But again, I would imagine that given the constitutional, for those jurisdictions that have written constitutions that guarantee the freedom to associate, the freedom to communicate and receive ideas, the freedom of worship and the freedom of religion, that if there are attempts at proselytizing and state action, either through the legislature or by government regulation, seeks to impose restrictions on that kind of activity, I believe that is both challengeable, and I believe in the constitutional context, the court should condemn, in the case of laws that restrict, should strike them down, because at the heart of the matter are the constitutional guarantees. the freedom of religion, the freedom to worship, the freedom to communicate and receive ideas. Any restriction imposed either statutorily or by governmental regulation tends towards a violation of these constitutional entitlements.
Judge Campbell, you don't be two this time?
In the United States that I'm obviously familiar with, that hasn't been an issue in the courts, because from the founding, the free exercise of religion has been understood to embrace the freedom to share views and to proselyte. And so that's been a common accepted practice. But I do have a couple of thoughts on that issue. In countries where that isn't the tradition, and in the question you've posed, Judge, it will be again the majority versus minority rights. And majorities generally don't need protection. Majorities have the ability to protect themselves. A unique function of the courts is to protect the minorities when the law provides the protection that they're to receive. And oftentimes, that will require the judge to rule against the government that appointed her, that writes her paycheck, that provides her office. And it requires judicial independence for a judge to rule against his or her own government in a particular case. In our United States Constitution, the religious liberties are written as constraints on the government. The First Amendment says Congress shall make no law respecting an establishment of religion or abridging the free exercise. It's a limitation on the federal government. The 14th Amendment makes it applicable to state governments. So when a judge in the United States enforces those constitutional provisions in favor of religious liberty, the judge is ruling against the government that employs the judge. And so I think on this issue, judicial independence is a very important principle. Judges who are beholden to their governments for their well-being and for their profession and their livelihood will have a more difficult time vindicating minority rights than judges who are independent. In our country, that's accomplished by making federal judges lifetime appointees. A federal judge can only be removed from office by impeachment by the United States Senate. The Constitution specifically says Congress cannot reduce the pay of any judge. So judges know under the Constitution they can't be fired, they can't get a pay cut because they happen to rule in a way that the government doesn't like. And that's one way of creating the kind of independence that will allow a judge to rule in a particular case in favor of a minority that might be seeking to proselyte. Independence is also needed with respect to popular opinion. Obviously, judges who are enforcing minority rights might be doing something that is very unpopular. That's not an unusual position for judges to be in. Judges have to have thick skins and be willing to be unpopular if the law calls for them to rule in a particular way. But I think both bear on independence, which bears on the question.
Justice Toliken.
Thank you. Perhaps I can start by saying that proselyting is part of my religion. I'm one of Jehovah's Witnesses, and that's exactly what I do. Even as a judge, I go and knock on doors. But doing that, I also need to say something again in our context. I said that Papua New Guinea, there is no really predominant denomination, Christian denomination. But then again, it depends on what part of the country you come from. And in one of the sessions yesterday, I said that for most of us, our religion, and that is, I guess, true for most countries or peoples who have been colonized, our religion is a mistake of geography, politics, history, and time. And that is true in the context of Papua New Guinea. So it depends on where you are. If you were in Bougainville, where I come from, the Catholic missionaries were the first to go in, so obviously Bougainville is 85% Catholic. But to the question of converting people and seeking out to convert people, in Papua New Guinea, whilst we have that diversity, we do not have such a huge problem. Again, it goes down to our culture, that we are very accommodating. Hospitality is something that we pride ourselves in, so it is un-Melanesian, un-Papua New Guinean, to reject somebody who comes to your door. But we have had no challenges. Nothing has come before the courts, to enforce rights of minorities, groups. I also know that the LDS are very much like witnesses. You go out and you need to recruit. But we have had no such challenges in Papua New Guinea. But going back to a provision in the Constitution, in our Constitution that provides for freedom of religion, I said it is a qualified right, and it is. There is a subsection in that provision which says that no person is entitled to intervene unsolicited into the religious affairs of a person of a different belief, or to attempt to force his or any religion or irreligion on another by harassment or otherwise. Okay, so this is a provision that has not come before the courts yet for consideration. Whatever differences we've had, they're sorted out amicably. So that's the situation in the context of our country.
Okay, well, let's turn to another issue that perhaps is not specific to the countries here, but we have three judges who are very experienced and would be able to see how the problem would be solved in their country. In many of the countries, including Pakistan, there is a blasphemy law which has created some difficulty in Pakistan and in other countries, in which there is a method by which the executive is able to interfere with minority rights through claiming blasphemy laws are being punished. And that was the situation in Pakistan. It had gone on for some time. Very courageous Chief Justice by the name of Jilani, who, by the way, has attended on one or two occasions this very symposium, Chief Justice Jilani wrote for the court a very important opinion. In the United States, the great opinion we look to for leveling out and giving people of color equal opportunities is called Brown versus Board of Education, in which the beginning of which was to provide equal schooling for people of color. And it was a traumatic experience for us, especially in the South and parts of the North. Chief Justice Jilani was well aware of Brown versus Board of Education and even quoted it in his opinion. But what he did was that he did a good history and had factual backup for his opinion. And in that, he found that the police, who are supposed to enforce the law, concluded and believed that it had counted for blasphemy only when it was against the Muslim religion, that it was not blasphemy against minority religions for there to be interruptions enforcing blasphemy laws. He leveled that out with a very important decision in which he said that and showed that blasphemy laws were to protect all religions, not just one, but all religions. This was a case in which there was a great turn of law dealing with religion, that it was a major change that was important not only to Pakistan, but to other countries who were having with the same difficulty, became somewhat of a precedent, although not a binding precedent, but what something one other country had done and was the way forward for changes in some countries. Chancellor Singh, in your country, two-part question, have you had any similar experiences as Chief Justice Chilani ran into in Pakistan, where the laws had been interpreted improperly to be of disadvantage to the religion or certain religions? And if not, how would your court handle the situation if it came up today?
I don't have any distinct recollection that we've ever had to adjudicate on an issue like that. I do know that our criminal law offenses statute prescribes against blasphemy and provides penalty for it. I am not sure that I'm aware of criminal prosecutions ever having been undertaken, though I believe in their daily pursuits, our people blaspheme almost every day, but they've not been brought before the courts. If such a circumstance were to arise, as a presiding judge, and again, I believe our Constitution, which is our supreme law, addresses almost every facet of national life. And taking into consideration the fact that our people are entitled to equal treatment under the Constitution, I would hardly think that our court, I would hardly think that I would rule partially to say that blasphemy applied only in the case of a certain religious persuasion. Blasphemy is blasphemy. And it is a matter that partial consideration ought not to be afforded.
Thank you. Justice Oakland?
The first part of the question, we have had no such experience. Nothing has come before the court, but we've had executive action taken by the executive government on material which was viewed as blasphemous, starting with, I think, In the Name of God by David Yellow, an investigative work on the death of Pope John Paul I. It was banned by our censorship board 3 months after it was released and sold in Port Moresby. The other religious, or the other text that had been banned by our censorship board was the Satanic verses. Now that's interesting because we have a very small Muslim population in Papua New Guinea. In fact, less than 0.01%. But, the executive thought that the Satanic verses need to be banned, even though no Papua New Guinean would have read the book. Okay, what happens if something like this comes up before us for adjudication? And again, like Chancellor Singh said, we will rely on our Constitution provision, which is, there to protect everybody, protect, minority religions as well as, those religions which are a little bit dominant. And I think, when it comes to this type of cases that come before the court, I can say that our courts in Papua New Guinea have been fiercely independent in regard to executive actions. We have provisions in our criminal code which touches on blasphemy, but nobody has been prosecuted for that. We have provisions that protect, that is in the code, which protect, your right to worship. It protects places of worship. And again, if I can remember, maybe only one person has been prosecuted for that. But for us, we fall back to the Constitution, the protections that are provided in there.
Thank you. Judge Campbell?
In terms of similar cases, if the question is, have we had similar sort of revolutionary cases that have significantly changed the landscape of human rights? Obviously, Brown versus Board of Education is the best example in the United States, and the one cited by Chief Justice Jelani. That was a case on racial equality that, as many of you probably know, held that it was a violation of the Constitution for states or cities to segregate black students from white students in public schools. The notion of separate but equal was unconstitutional under Brown versus Board of Education. It's interesting that although that decision was handed down in 1954, it came back a year later because nobody was following it. And the Supreme Court had to take more significant action and actually directed district courts to enter very specific orders requiring school boards and cities and states to change the way they manage their education. And that led to several decades of turmoil in the United States as courts sought to enforce that right, resisted greatly in some parts of the United States by people. In fact, the Board of Education that was sued in Brown versus Board of Education, which was in Topeka, Kansas, was not declared by the court to be racially equal until 1998. 44 years after Brown versus Board of Education was entered. There was a culture change that came about as a result of that Supreme Court decision, but again, it was the court applying the Constitution as it understood it. On the religious liberty side, we haven't had a similar revolution, but there have been controversial religious liberty decisions. As you probably know, one of the protections in our Constitution is against the establishment of religion by government. We have a provision which says we shall not have a state religion. And the Supreme Court has relied upon that provision, for example, to say that schools cannot make prayer mandatory in the classroom. That is an establishment of religion. That has been and continues to be a controversial decision of the United States Supreme Court, even though that is now more than 40 years old. But I wouldn't say there's been any sort of sea change cases like Brown on the religious or on the religious freedom side.
Thank you very much. This Brown case, of course, is significant because it happened in the South. And the judge who made the ruling was a federal district judge. He had lifetime tenure. No judge appointed by the state would have dared write such a letter because they'd be out of office immediately. But because we have this lifetime tenure in the federal district court, judges can rule the way they ought to rule, even though it's very controversial, even though 90% of the people may disagree with it. And this was not lost on Chief Justice Jelani. He cited Brown 1 and Brown 2 in his cases. And if you haven't read Justice Jelani's opinion, it's quite a major case where the Chief Justice took the position that not only does the Constitution forbid discrimination against minority religions, but the teachings of the prophet are opposed. And he quoted the teachings of the prophet that he was relying upon. So he not only relied upon constitutional law, but religious law. in his development of his opinion. And so it is almost, if you follow his opinion, unless you change, you're anti-Islamic under the opinion. It's a very, very broad opinion. And as with Brown versus Board of Education, it'll take years to make changes, but you have to start somewhere, and he's done that. Now we have just short of a half hour for you to ask questions. We're going to do one thing right away. We're only going to allow one question per person, so choose the question. You can't say and. You can only ask one question, and then you have to stop, and then we will take another person and let them ask a question. You may direct it to a judge if you wish, and then provide. Do we have the speakers over there? We'll start with this gentleman over here, please.
So I'd like to take advantage of your esteemed expertise in a case that's coming before the Canadian Supreme Court at the end of November. Trinity Western University Law School versus the Law Societies of Upper Canada and British Columbia. Trinity Western University in Langley, BC, is a private, free evangelical university that is seeking to establish a law school. Like BYU, they have an honor code. They call it the Community Covenant, which stipulates that students and faculty at that university have to abide by Christian teachings on marriage, sex before marriage, and so forth. This has been interpreted by many in Canada, by many within the LGBT community, as being discriminatory towards people of a same-sex orientation. The Law Societies of BC, Upper Canada, and then the barristers in Nova Scotia said that they would not accept any graduate of such a law school to practice in those jurisdictions because they would be biased towards people of a same-sex orientation. So these are lawyers and their law society arguing this. In the cases before the Court of Appeal in the three jurisdictions, both BC and Nova Scotia found for Trinity Western, Ontario found for the Law Society of Upper Canada. This is really seen as a landmark case coming before the Supreme Court. What happens when lawyers themselves and law societies establish a position like this, where they land very firmly on one side of a particular right, freedom of expression in this case, freedom of association perhaps? What do you do in this situation? This is really a landmark case.
Okay, now, are you directing that question to anyone in particular?
Broadly to the panel.
Who wants to start?
My immediate response in relation to the position of the lawyers is that they've arrived at a sad day, a very sad day, because I would think immediately that those stipulations are inherently discriminatory. And so I think the outcome in the Supreme Court can be foreseen.
I guess I have just a couple of thoughts. I think part of the question was, what does a judge do when a law society and lawyers come to the judge with a strongly held opinion that this is what the law ought to be? And my view is the judge doesn't take that into consideration at all. A judge has a responsibility to make a decision without regard to that judge's personal views of the parties before it, or whether they're friends, whether they're professional colleagues. All of that should be completely irrelevant. So I would hope that in that case, the fact that the law societies have aligned with one side of the case will have no influence on the outcome. I don't know Canadian constitutional law and how a court would rule on that, but I have to say it seems to me to be a very hazardous venture for law societies to get into the business of deciding who is and is not biased based on their personal views and therefore fit to become members of the bar. Where does that process stop?
We only have one microphone, is that right? Pardon? Sure. You'll wait for me to call on somebody, please, if you would, please. Go ahead.
I just
Would you
wanted
get the
to,
microphone, please?
I just wanted very quickly to relate a case, an actual case in Guyana. A group of transgender men were brought before the court for wearing female apparel. And we have an old inherited section in our criminal law statute that makes that offense if wearing the clothing of the opposite sex is for an improper purpose. And the case came all the way to us in the Court of Appeal. Of course, I felt that there was no, in the evidence in the lower court, the prosecution had not advanced any evidence of their acting for an improper purpose. It's just that they were wearing female clothing. And I gave the ruling of the court. I began my ruling by saying that deviant behavior in the Bible has been described as an abomination in the eyes of God. But having said all of that, having given these four men a tongue lashing, I then said, but this case cannot be determined on biblical prescription. It has to be determined in accordance with the law. And you are entitled not to be discriminated against and to equal treatment. And so we reversed the conviction that had been imposed in the magistrate's court. But I gave effect to my religious values.
Yes, sir. Down in front here. And make your question as short as possible, if you could. And to whom will it be directed?
I'll address my question to Judge Campbell. The United Kingdom, and I think the same issue applies in the USA, has laws which prohibit denial of service by shopkeepers, etc., based upon various characteristics, one of which is sexual orientation. And we have a case where two gay men wanted a cake to celebrate their gay wedding from a bakery, and wanted something like, four gay, celebrating gay marriage or something like that on the cake. The bakery was owned by devout Christians, considered supplying cake to be a violation of their own religious belief. The case is currently being litigated. If that case came before you, how would you rule?
I can honestly answer that by saying I don't know. I would need to read the briefs. I would need to hear the arguments of the parties. I would need to study the issue. I will tell you that you have, with perfect accuracy, described a case that is before the United States Supreme Court this term. Maybe you intended that. And it will be argued in December. It comes out of the state of Colorado. It is a baker who declined to bake a cake for a gay wedding. The courts of Colorado found that he had violated the Colorado discrimination laws, and that's been appealed to the United States Supreme Court. The argument of the baker is not only that I have a religious belief that prohibits me from supporting and endorsing a gay marriage, but he is also arguing that my baking of cakes is a form of expression. I create these cakes with a message to celebrate the event. I write on them. I design them for the event. And if I have to bake a cake, I am being forced to express my views in a particular way, and that violates my constitutional right to free expression. Of course, on the other side of the argument are the men in that case who are going to be married in the gay wedding saying, you are offering a public service as a bakery. It's like a hotel or a restaurant, and everybody would say you can't deny a room in your hotel because somebody is a racial minority. This is no different. You are choosing to discriminate against particular people, and we have a long history in this country of not allowing discrimination in public accommodations. It's a very good illustration, I think, of when rights come into conflict with each other, and it falls to the courts to decide what the result will be. There's a lot of discussion in the United States right now about how that case will come out. It's a very important case. I think most people are of the view that the 4 so-called conservative justices will rule in favor of the baker, and the 4 so-called liberal justices will rule in favor of the men who wanted to be married, and the deciding vote will be Justice Kennedy, as he has been on so many critical issues. And what makes this particularly an interesting case is that Justice Kennedy, as you might know, has been the foremost advocate of gay rights in the Supreme Court, but he also has a very long history on the court of endorsing religious freedom rights. I don't know how Justice Kennedy will work that out in his own mind, because he believes strongly in both rights. But I can honestly say, until I heard the case and read the briefs and considered it carefully, I don't know how I would rule.
Halfway up on the left, please.
Thank you very much. I have a question for Justice Campbell as well. Establishment clause. We heard yesterday that...
To whom do you wish to direct the question?
Justice Campbell, please. We heard yesterday that we need to stop leaving our religion outside the door, and so as diplomats we should be able to speak on our religion, use it in our active sense of duty. Establishment clause, U.S. State Department. Do you see the U.S. colleagues starting to do that? We hear that they, now under the new administration, some of their meetings start with a prayer. Is that conformant with the Establishment Clause? And yourself, you mentioned the whole setup, the makeup of a court. When you enter the court, do you leave your religion behind? You talked about the composition in racial terms, but should we also look at it in religious terms? Would something prevent you from going out as your colleague from Papua New Guinea and express or proselytize in your free time, or would that be seen as a conflict? I'm not a lawyer, but I'm trying to understand how your system works.
Yeah, good questions. A few thoughts on that point. The Establishment Clause religion is a restriction on government. So it says that government will take no action to establish a religion. That is not a limitation on individuals. And so it's been generally recognized that an individual, even a government official, has a right to the free exercise of religion and to express their religious views. But the government can't officially endorse a religion. So there is nothing that prohibits me as a federal judge from standing up in my congregation on Sunday and expressing publicly my religious beliefs and endorsing and advocating them. I have that free exercise right. It would be entirely inappropriate, in my view, that when I'm sitting on the bench and I'm wearing the robe in front of the flag, acting as a judge, for me to advocate my religious views. That would be in a governmental function that I would be doing it. It's a difficult issue. What happens when a person in an official position expresses views, such as the people in the State Department? And there's a debate about that. I will tell you the Supreme Court has held, and it's tried to walk a fine line, that it is okay for a legislature to open its session with prayer if it is either a non-denominational prayer or if all religions are given the opportunity to offer the prayer, so that there's no official establishment or endorsement of a religion. It's entered similar decisions with respect to city councils and things such as that. But there have been other cases where the legislature said, we will have a Christian prayer in the opening of all of our sessions, and the courts have said that's an endorsement of religion, and that the government cannot do. There are lots of shades of gray in there, and different people have different views on what is or is not appropriate, but there is a general recognition that there's a clear distinction between private and public life, and I could do exactly what my colleague does and go out and actively proselyte for my religion as a private person.
Please, go ahead. Yes. Just a second, let Chancellor Singh respond, then we'll hear from... Yes.
Thank you, Judge Wallace. I wanted to go back to the baker and the cake. I would perhaps put a slightly different perspective on the issue. And I would see it as perhaps being capable of being resolved under the law of contract. The baker is clearly electing, influenced by his religious persuasion, of course, in not wanting to contract with a person for the particular reason. So there is that entitlement where he has the freedom to contract or not to make the cake. So in that context, I would have some difficulty in seeing how a contention of discriminatory treatment can be leveled against him. Of course, David has raised the point about discrimination in public life here in the United States. I doubt that is something that will be accommodated in my country. I think that issue is quite likely to be resolved in the law of contract.
As you may know, from the beginning, the Supreme Court is called into session, and the end phrase is, "God protect this honorable court." And the same thing is done in many of the district courts throughout. And a colleague of mine said that the person who the bailiff, the first time he came on the bench, the bailiff missed the prayer a little bit, and he said, "God save the United States from this honorable court."
Bom, Ivani dos Santos, Brasil, vou falar em português.
I'm going to speak in Portuguese because I'm Brazilian.
Eu acho
I believe that this conversation is really interesting, but we have to notice how far do the rules get to the common people, where the judicial actions, instead of protecting, end up incentivizing discrimination. There was a case in Brazil when we enter the court to be able to get it off the internet, the attacks that the proselyting groups were doing against African religions. To our surprise, the judge, in receiving the decision, he said that Candomblé and Ubanda, they were not religions from the book. So in other words, he wasn't using the law, he was using his personal religion conviction. This has happened quite a bit. This happened a lot. Let me tell you some of the things we've talked about: religious tolerance. The judicial has omitted these types of questions, be it the police that doesn't investigate, and be it the public ministry that doesn't talk about it. But we have two important informations. Primeiro was the Brazilian court's decision that challenged the religious education in school. It discriminates against the minor religions. If you're talking from a Christian religion, it's correct, but other religions, it's not. And the other challenge that the court will do is in regards to religious religious approach. If it's Muslim or Christian religious, it's important to know that the Brazilian law accepts that. But if it's a minority religion, such as African religions, it's in essence, African religions are discriminated against.
Again, I would like to relate the answer to the constitutional provisions of my own country. And the position is clear. It's not given to any ambiguity in terms of its application. So that the guarantee to every citizen is that no one shall be discriminated against on the ground of race, class, religion, or sex. And it is in that provision where lies the answer to the dilemma in Brazil, if there is such a provision.
Dave?
Well, part of the question, or part of the comment was that there are judges you have seen who have let their own religious views influence the outcome of the case. From my perspective, and I think the perspective of our judiciary, that is entirely inappropriate. The fact that I am LDS should have nothing to do with the decision that I make in a particular case, and I should make every effort humanly possible to set aside those views and any other personal views I have, and to apply the rule of law. That's what the rule of law means. I'm applying the law, not my own personal perspective on what the law ought to be. And judges who don't resist that temptation and impose their own personal views are not following the rule of law.
Perhaps I could just add that, most judges are affiliated to a religion, so it's a tough job. But, for me personally, I leave my religion outside the door when I come in. And I take the same view that Voltaire took when he said, in respect of freedom of speech, that I may disagree with your beliefs, but I will defend your beliefs to death, from where I'm sitting as a judge.
Well, thank you very much. We're running almost out of time. First, I want to thank my colleagues here who trusted me enough to come up here and expose themselves without script or note. And I hope that you have enjoyed their responses too. I wanted to just comment, if I could, on the last question. In our judiciary, you are required to recuse yourself or step off the bench if the issue is one in which you believe you could not be fair to both sides. And so the judge is put under the responsibility that if his or her religion would be dominant, would be even considered a part of it, if they could not set it aside, then they would get off the bench. And that's the important part of what needs to be done in all of these issues. I can only think of one time I stepped off the bench and recused myself for a case that I felt I could determine, but I didn't think other people would believe it. It had to do with a tax case and whether or not grandparents can donate to their grandchildren missions. And I have 15 children and 50 grandchildren, and I knew I had to get off that case. Thank you very much for your kind consideration. Now, as usual, we have someone that's going to make some announcements now. There's never been a time in the history of the conference that someone didn't come up and give a housekeeping announcement. Is there one? Well, this will be a first then. In your booklet, you'll see where your next class is to be in 15 minutes. And finally, let me thank my three colleagues for being so brave as to accept the assignment and the wonderful job they've done.